Okay, because I want you to get optimal knowledge, because I want it to be easy for you to get knowledge from me. I read your comments and I tend to agree with you when you say that you do not see my board. And I'll say, okay, let me even try as much as possible to change the marker that I'm using. So I've been using a green marker, and of course, you know how shouty green can be. So I have changed the marker. So comment if you can see it. I wouldn't know because looking at it from here, I think in my own eyes is okay. But of course, I cannot use my eyes to judge because I used my eyes and judged that the green marker was okay and it was not. Again, most of you said you cannot hear me, that sometimes it's the volume is low, sometimes it's high, that I should stop pinning the mic to my chest. So that's why I was looking for what to use and do this thing. I couldn't find the spoon that I saw. So you have to bear with me. The only thing is at least you can hear what I am saying. So today is for my year one students. I'm doing classifications of law today. When next we meet, we'll still do techniques of social control through law. So today is classifications of law. So most of the times when we've done the definition of law, you know what law is. Yeah, we've done the objective of law. What is law seeking to achieve? Now we will go into the classifications of law so that you will not be confused. You know, as a legal practitioner, you need, or as a future legal practitioner, you know, you're no longer in equity, you're a legal practitioner, but of course, there's equity here. So you have to, most of the times, I think most of you have been hearing, most of you that have started, they start calling you lawyer in equity. But you don't know what it means, but you know it today. Why they call you lawyer in equity. You understand? Not law student. So, as a lawyer in equity, or somebody that is going to be a lawyer in the future, you need a grasp of these classifications of law. So that when a client comes with his problems, in your head, you're already classifying the problem. For example, a client comes and says, my landlord chased me out of the house. He carried all my goods, all my properties, brought it out, and even beat me up on top. In your mind, because you're a legal practitioner that has the good knowledge of classification of law, you already say, okay, assault, he beats you up. Your landlord beat you up. Criminal law has entered your head. Okay, assault can also be a tort, T-O-R-O-T. Civil law has also entered your head. Still on the same classification of law. Okay, because it's between you and the landlord, private law, in citizens. You understand? So when you are going to court, you know that, okay, it's either you ask for damages, common law, or you ask for specific performance for the landlord to reinstate you in the house, equity. Now you want to know, okay, how will you bring this matter to court? They have come with you, my landlord tells me, how will you bring it to court? Procedural law. Okay, if you go to court, what law will you be quoting for the judge that this is what the landlord went against? Substantive law. So because these laws are inside this Nigeria and it is applicable to Nigerians, made by our legislature to be applicable to Nigerians, it is municipal law. So, because of your knowledge of classifications of law, you have been able to classify this particular scenario now within these classifications of law. And you cannot do it if you don't know the classifications of law. So that is why I'm here, to teach you and to explain these classifications of law. Now let us start. The public and the private law. Public law, private law. Now, public law, these are laws or body of rules that guides the relationship between the citizen and the state. When you say public, for example, you say public school, what does it connote? It connotes government schools. Yeah? Public parastatal is government. So anything public law, we are talking about the government, laws regulating the government, laws regulating we as citizens and the government, the relationship between we as citizens and the government. So that is public law. And under this public law, you will see topics or courses like constitutional law that talks about the structure of the government, that regulates the powers and functions of the government, talks about the structure of the country, constitutional law. You talk about administrative law. talking about the functions of government parastatals, it is under public law. You even talk about criminal law under public law. When we get to criminal law, civil and criminal law, you will understand what criminal law is. But under public law, we are talking about government. Anything public is government. How is government supposed to do things? When you do your constitutional law in your 200 level, you would see that there are some acts that are ultra vires. Now, what is ultra vires? There are some acts that the president or the governor would do that it is outside the scope of his authority. It is outside the scope of his powers. So when this president or this governor goes outside the scope of his powers, what do? You can bring an action in court for the court to declare that particular action unconstitutional and ultra vires. And once you want to bring that particular law, once you want to enforce that particular law, the particular law you are enforcing when you bring these government people to court for the court to declare it unconstitutional and ultra vires is public law. That is the classification of law you are looking at. There are people that do their masters in public law, constitutional and human rights law, public law. Now, private law is the opposite. Private law is now laws that are regulating the relationship between individual and individual, citizen and citizen. So you see laws or topics or courses like law of contract that talks about, is there contract existing between these two parties? What are the parameters to measure if there is a contract existing between these two people? Law of contract. We have law of tort. Tort is civil wrong. T-O-R-T. Civil wrong. Ah, you defamed me. You seized my goods. Dating you. Private law. Law of tort. Yeah. So, public law, government. Private law, citizens. Simple. Very simple. Now we have the civil and the criminal law. The civil law these are laws just like the private law. The civil law are laws that guide the relationship between a citizen and a citizen. It has almost the same meaning with private law, but in this context, we are going to be contrasting it with the criminal law. The criminal law is the body of rules that has the interest of the society at large, that it punishes people that would want to come and commit offenses that would be in the detriment of the society. That is why anybody that commits a crime, it is not the individual they commit the crime against that will start charging the person to court. The police will arrest the person. The police or the Ministry of Justice, which are the workers or the employed lawyers of the state, would have to come and charge the person to court for an offense they committed. Why? Because one of the primary function of government is to protect the lives and properties situated inside the state. So one of the ways they do that is under criminal law, where they guide against crimes. And so if you are found wanting, if you commit a crime, it is now the states that will arrest you, the state will charge you to court, and hopefully when they prove beyond reasonable doubt, you can now be sentenced to whatever it is they want to sentence you to. But civil law on its own is just your relationship between you and the other person. So that when somebody does something that will affect your own ego as a person, your own person, somebody is breaching a contract between the two of you, then you will sue the person. You will not be waiting for the state to come and carry the person. You will sue the person because you suffered injury. Yeah, and it is the person that made you to suffer the injury. So you sue the person and you ask the court to order the person to give you remedy, damages or anything. But criminal law is different. Now, what are the differences between this? Under civil law, you are expected, because it is two individuals, two citizens, the court will treat them equally. Now, there is an imaginary scheme of justice where if you want to ask the court for any remedy, you must bring your evidence for the court to make sure that you actually suffered injury. And if you bring your evidence and the other person brings his or her own evidence, they will put it in an imaginary scale of justice. And anybody that the weight of the evidence tilts towards, that is the person that the court will give judgment. That is the person you say he has won the case. And that is what we call proving your case on the balance of probabilities or on the preponderance of evidence. Yes, it's English language. On the balance of you in civil law, you prove your case on the balance of probabilities or on the preponderance of evidence. It's just where is the weight of evidence tilting towards? It is not that you carry out weight of evidence is not measured by how many evidence you bring. You might bring 100 evidence and one person will just bring one evidence and it will bring down the scale of justice, and the weight will be so much that it outweighs your 100 evidence. So it is the weight we are looking at, not the number of the evidence. While in criminal law, you prove your case beyond reasonable doubt. Why? Because just like the court will give the two individuals that are coming under civil law equal standing in order for them to prove their case. But in criminal law, the court is giving the accused, or as we call it now, the defendant, a favorable standing more than how it is given the state. Why? Because the state, of course, is powerful. And the court will try as much as possible to protect the accused or the defendant from the powers and from the intimidating authority of the state. So we are starting the case by presuming that the accused is innocent. So it is now left for the state to prove beyond reasonable doubt that the accused is not innocent. Now, if you look at your Constitution, section 36, sub 5 of the Constitution, it says that every person is presumed innocent until proven otherwise. So that's about criminal law. So you are coming innocent. It is now left for the state to prove that you are not innocent beyond reasonable doubt. Now we'll go into common law and equity. Now, pay rapt attention because we'll go into history now. Now, common law, first of all, is when you look at common law and equity in your sources of law, you are looking at it under the received English law. Because these ones now are English laws. And because we were colonized by the Britain, we received these laws into Nigeria, and it is working in Nigeria now. Common law. These are sets of rules developed by the old common law courts. Common law courts are consisting of the King's Bench, the Common Plea, and the Exchequers. These common law courts developed these common law principles out of the prevailing customs of the English people. So let me put this in context. And it started developing after the Norman conquest of 1066 AD. So after 1066 AD, after the Norman conquest, it was the idea of the king at the time that instead of these people coming to this palace, instead of these people coming to this place to get justice, why not let us take justice to them? The king now empowered the judges to go into the villages and adjudicate on matters. Now, when these judges go into this place, and adjudicate on matters, they will come back to Westminster. Of course, that's where the palace is, the seat of power. And they will discuss these judgments that they have given. And this one will say, this your judgment is very nice. This person brought this. So when they now go back, if they encounter such problem that, okay, we have discussed, and one judge in our meeting, me, I'm a judge, but one judge in our meeting has said that when this case came, this was how he did it. So when I am in this, my primary place of assignment now, that I am trying to adjudicate matters, and that particular kind of case comes, judicial precedent. That particular kind of case comes, I am to use the logic that other judge used to judge the case instead of using the customs. Yeah? So Remember that when they started off, they were using the customs of the people to judge them, to judge the matters between them. But as time went on, they started using what they have judged before in the past in different places to judge a matter that is now before them. That is why it is called common law. It now became common throughout England that if you know, if somebody steals your pen, this is exactly what will happen. It is common. Everybody, it was predictable. Everybody could predict it. But there was a problem with common law. Yeah? Common law was very rigid. You must have to execute a particular thing, like a writ like a paper. If your course of action does not fall into the available writs that are available, the writs that are available, then you don't have any course of action. So you must have to execute a writ in court before they will even hear you. So there were a lot of technicalities, there were a lot of formalities, there were a lot of rigidity. So when it was seen that many people will go to common law, and because they don't like the rigid nature of common law, they will now, after common law has given them their judgment, they will now go to the king. King, I don't like this thing. The king will now say, ah, please, I'm very busy. I'm very, very busy. Um, Chancellor, Chancellor, who was the king's prime minister, handle this matters, please. So they will bring it to the king. The king will direct you to the chancellor. The chancellor will handle the matter and give you equitable remedy, give you judgment that is okay, judgment that you look at and say, okay, it's okay. So people were enjoying it. People were now going to most of it, they will go to the king will automatically direct them. So when they will go to the king and the king will direct them to the chancellor, they need not to go to the king again. Now let us just go straight to the chancellor now. Since if we go to the king, the king will direct us to the chancellor. They now started going to the chancellor. That was how equity was now developed by the court of chancery, by the chancellor. So the common law people were now angry. How is it that if you give judgment, the chancellor will now go against what we did and overturn our judgment? Are you court of appeal? Is that an appeal? Is that an appellate court? They were angry. And the particular case that showed this anger very well was in the Earl of Oxford case. In the Earl of Oxford case, you must know this case. In the Earl, he can see it, Abby. Earl of Oxford. In the Earl of Oxford case, in this case, the plaintiff is the person that sues. The plaintiff leased a land from the defendant. And when he lease means he did not buy it, but renting, rented the land. He built on top of the land, planted gardens. When he wanted to park in, the defendant chased him out of the house, ejected him from the land. He went to common law, the common law court, and the common law court says that the defendant is the owner of the land. So that is it. Bam, finish, leave the place. He didn't like the judgment. He went to equity. He went to the Lord Chancellor, the Chancery. And equity says, no, based on fairness, you must have to live in this house that you have built. That the defendant should not chase you out of your house. Common law people now started crying. Who are you to go against what we have said? Who are you to upturn our judgment? They now carried it and they came to the king. And the king now stated that when common law and equity clashes, equity will prevail. Now, equity in the technical sense of equity means fairness. It means fairness. It means giving to people what actually is accruable to them. So that was it. So the common law courts were doing their own thing. The equity courts were doing their own thing. So it was separate. They were doing it separately at the time until 1875. 1875. What happened in 1875? 1875, there came a Judicature Act. Judicature Act. And the Judicature Act of 1875 now fused the courts, common law court and equity court, into one court. And one court can now adjudicate on the principles of common law and also adjudicate on the principles of equity. And remember that while adjudicating on the principle of common law and equity in those courts, that any time that the common law and the equity clashes, clash, that equity must prevail. So now I will give you an assignment. Give me a historical evaluation of common law and equity. Read before you write it down. Send your answers to my email. If you don't do it, it's your own cup of tea. If you do it, you're helping yourself. Send it to my email. I'll put my email on the screen now. Send it to my email, and I'll be waiting for it. Now let us go to substantive and procedural law. Now, when you talk about substantive law, you're talking about that law that you are studying now. All those your contract law, your criminal law, all of them, you are talking about the law that defines the rights and duties and obligations of citizens. Substantive law. The laws that talk about the rights, the obligations, your duties as citizens, the do's and don'ts. Don't do this, don't do that, don't do this, don't do that, do this, do that, do this, do that. That is substantive law. The law as it is, the law like as the law is prescribing, and the do's and don'ts, that is substantive law. But if substantive law just existed alone without the way to enforce it, it would be like a toothless bulldog. So let us say the law says don't wear clothes on Fridays. That is the law, substantive law. Now, if you now wear clothes on Friday, what will happen? That thing that will happen if you go against the law and wear clothes on Friday is now procedural law. Procedural law is now a law or body of rules made to enforce the substantive law. That is procedural law. So when you talk about substantive law, you're talking about your criminal law, you're talking about your another criminal law. You have the criminal code that prescribe crimes for the south and penal code for the north. So it is under the criminal jurisprudence, criminal law jurisprudence. You have your electoral act, even though some procedural things are in the electoral act. So all these laws that talks about the do's and don'ts, substantive law. Then all these ones are not talk about how do you now go to court. What do you now do when you arrest somebody? What are the rights accruable to somebody that was arrested? How many days will you stay? How will you charge the person to court? What will you use to charge the person to court? You understand? That is procedural law. Another procedural law, we have laws like the Administration of Criminal Justice Act. Then we have the Administration of Criminal Justice Law of different states. Civil procedure rules. So High Court civil procedure rules. We have the Supreme Court procedure rules. We have the Court of Appeal rules and all that. So that's procedural law. Now, municipal and international law. Municipal law is the same thing as domestic law. Laws that are made for Nigerians that guide us within our country. While international law can be laws that guide our relationship between two countries or our country and the international organization. I don't know why I'm saying our. Is laws that guide two countries, or a country and the international organizations. And examples of these international law can be treaties, conventions, charters, just like we have the United Nations Charter, we have the UDHR, we have all these things. All these things are international law. Laws that are not just within our municipalities. Now, examples of municipal law, of course, you have your criminal code because it is guiding us in Nigeria. Another thing you have to know about international law is that it's divided into conflict of laws and public international laws. This conflict of laws can be seen as private international laws. Then this public international laws is the one we call normally international law. Don't know if you understand what I'm saying. So, what's a conflict of law? So, when you are trying to know the kind of law to apply, when maybe you have been to different countries to do something, for example, um, if I am here in Nigeria and we are to do a contract in London and you are in London and you breach the contract, where will I sue you? Conflict of laws. Which law will apply? Conflict of laws. Public international law is the normal, um, between countries and others. So we've come to the end of the classifications of law, and I hope you learned something today. I gave you an assignment. Give me the historical evolution of common law and equity. Read, research, and do these assignments. I'll be waiting for it because you would still see it in your sources of law. So you better understand it now so that when you get to your sources of law, you would get it well. I hope these have been very good. Thank you very much for your time, and God bless you.